coverage of the news media has been a constant threat to me and my attorneys in an attempt to prepare a defense. It has jeopardized and I think in fact succeeded in influencing the final outcome of this case. But the interference, or that is the coverage by the news media as pertains to me, did not start with the filing of the indictment in this case. And their vilification of me and their attempt to make a celebrity or a notorious, infamous character out of me did not begin on July the 28th of last year, although the court will recall seeing the videotape of the evening that Sheriff Casares read me the indictment. And it's sad but true that the media thrives on sensation. And they thrive on evil, and they thrive on things taken out of context. I've seen it time and time again, and I sat in this courtroom and listened to the testimony coming from the stand, and then read the next morning an article written in a newspaper, and wondered if that reporter was actually in the same courtroom I was, misquoting people, attributing comments to attorneys who didn't say things, taking all sorts of things out of context. And I'd just like to show the court something. It's kind of amusing. See this photograph in front of the Herald. It's kind of a grotesque picture. I was quite furious when I saw it, because
I bet your mother told you to put your hand over your mouth when you yawned years ago, Mr. Bundy.
But you know, Gene Miller, who wrote the article, said that, in referring to this photograph, it was then that Bundy arose, mouth agape, saying nothing. He motioned ambiguously with his right hand to his head. It made little sense, nor had his crimes upon sleeping college students in a Tallahassee sorority 19 months ago. A small thing, but you know, that's what I've been fighting from the very beginning. That kind of out-of-context inference. Let me tell you what happened, and maybe liven up proceedings a little bit. Margaret Good and Lewis Karras were talking about Margaret's impending contempt citation when the court was leaving yesterday. And Margaret was asking Lewis why he hadn't stopped her. Now she was in trouble with the judge. And I kept hearing this banter back and forth, and I said, "You two sound like Laurel and Hardy." So when the court left, I stood up and I sort of did my Laurel and Hardy imitation, saying, "Look what a mess you got me into." Made the flashback. He took that picture, which is right here. And Gene Miller, in his infinite wisdom, attributed that to some ambiguous something that made little sense, and then connected it to the crimes of the Carnegie House. It's the interpretation of my behavior, as innocuous as it might be, it's the inference that no matter what I do, there's something strange or evil or demented behind it, that has been plaguing me ever since my prosecution in the state of Utah. I'm sure they took lots of photographs yesterday, but they loved this one. They could have printed any number of others, but they loved this one, because it made me look like an idiot. When they don't know, they had no idea what was going on at the counsel table. I guess that teaches me a lesson not to do any imitations at counsel tables again, but it certainly reaffirms a lesson I learned long ago, that the news media is out for blood. No. The single most devastating article, most prejudicial and most harmful in my case, written in the Carnegie case, written in the past year, was written by Gene Miller, when he took it upon himself to broadcast the remarks made by Richard Souveron. The court found that Dr. Souveron had not acted unethically, and had no reason to believe that his remarks would be published. And perhaps he didn't. But the conniving and enterprising journalist that Mr. Miller is, he took it upon himself to ignore my rights to a fair trial, to ignore my right to confrontation under the Sixth Amendment, my right to cross-examination. And he published that article, which I think remains, again, the most devastating pretrial article we've seen in this case. It started a controversy on the matter of the dental evidence. It still raises, and as we know, and as I said before, the dental evidence was the most potent evidence presented by the prosecution. Mr. Miller gave me a book. It's called Invitation to a Lynching. And when he and other members of the news media began covering me,
You gonna talk to me or you gonna talk to me?
I'm not sure this, Mr. Miller. They were making an invitation to my lynching, figuratively speaking. The news media long ago sent out the invitation to my lynching. And we're going to witness it today.
We're not gonna witness any lynching today.
In a figurative sense, I'm sorry. I don't mean to imply the court is a hanging judge. Camera in the courtroom. I've often wondered about it. You know, it's always staring at me when I was sitting at counsel table. And I wondered whether the publicity or the coverage of this trial brought about by that camera was perhaps a beneficial thing, keeping the court on its toes, because there are probably lots of people, judges and attorneys around the state are watching this court, watching behavior of the attorneys, and see if it measures up. And I thought, well, maybe that's going to inspire a higher degree of quality on the part of the performance of the parties. But that's only a short-term effect, if it exists at all. The long-term effect of cameras in the courtroom can only be detrimental to me, and only detrimental to the system. If we sat in here, as we often did, between 9 o'clock in the morning and 6 o'clock at night and have 7 hours of court proceedings, the news media people will take their 7 hours of tape and reduce it down to 5 minutes. And it becomes incomprehensible, that out-of-context piece of tape makes the whole process unintelligible, incomprehensible, and sensational. And I think that hurts the system. I think it makes the court, makes me, makes my attorneys look kind of weird sometimes, saying things and acting in ways that don't seem to comport with a lot of people's belief that this is supposed to be a serious, stern proceeding. The news media loves entertainment. They're out there entertaining people with news, selling news. And this court, is a good-natured court, and from time to time there would be a joke from the bench or a joke between counsel, and I'd see that that'll be on the nightly news. Now, certainly, this is not a comic proceeding. Far from it. I know the court realizes that. But what does that make people think about what's going on in here? When they see 5 minutes of laughing and joking and kicking around and everybody's having such a good time in this murder trial. Or if they take something else out of context. 2 minutes of testimony of Dr. Levine. Whatever they do. That camera in the courtroom is destructive to this process. I'd like to talk about choice of counsel, but only briefly. I remember when I brought the issue up a week or so ago about me representing myself, the court said, well, if you're a brain surgeon, you wouldn't operate on yourself. And I started thinking of that analogy in its real perspective, and I said, well, think about the education a brain surgeon has. There are some brain surgeons I would have rather represent me in a criminal trial than some attorneys. Because, let's take the medical profession. 4 years of medical school, plus 6, 7, 8 years of residency before they can go out on their own. Think about it. We have attorneys doing brain surgery after 3 years, in sort of a symbolic sense. There's nothing that prevents a newly graduated law student from representing a person in a capital trial. And I think this is a shortcoming of the legal profession. And I think that sometimes we have to understand that because a person is an attorney does not mean that he or she is has the experience to deal with a situation, deal with a trial in a way that amounts to effectiveness of counsel. Not to say they don't work hard or try hard. If you gave me a violin right now, I'd try to play it. And I'd try real hard, but I couldn't do it. I wouldn't be effective at it because I didn't have this experience and training.
I hope if you had 7 years of schooling, though, you at least could play Dixie or something like that.
Yeah, well, we heard a lot of Dixie here. We didn't hear any Brahms. And that's the problem. We didn't get the level of effectiveness that was required by this trial. And Your Honor mentioned memorandums written last week and said, you've never seen so many memoranda and so many such well-written briefs. And I agree with you. We've had a veritable avalanche of written documents from the defense in this case. And you know who prepared the bulk of that research? Those two first-year law students sitting out there in the office, in the audience. Now, certainly they're not qualified to represent me. They had a lot of time. They worked themselves silly in the law library. But a stack of memoranda does not make a case, does not make a defense. And I'm not going to go into what happened in this courtroom. That will be gone into later. But there's a great deal more to this case than memoranda and a lot of legal citations. And I feel through a combination of lack of experience of counsel and lack of preparedness that I did not have an effective defense. I'd like to talk about the court for a minute. Never like everything the judge does. I never have. I like some judges less than others. And I think that when a job's well done, it should be praised. And I think this court has made a number of rulings and labored, as the court has said, labored in a way in certain things, and the court should receive, it receives my appreciation for that. It's a hard job. On the other hand, and there is another hand, I think the court erred, and that's my opinion. And that's a different side of the coin. But the error is human. And that's why we have appellate courts. And so, on balance, Your Honor, I feel it shouldn't be left unsaid. The court had a tough job. I know I've seen a lot of different faces from the bench. I've seen concern, I've seen humor, I've seen anger, short temper, I've seen great tolerance for something, a whole breadth of emotion. And I guess that kind of indicates to me that Your Honor's robe notwithstanding, you are human. And I think that's the thing that stands out in my mind most. In the months that we've been in this trial. Now, yesterday, Larry Simpson was making his closing argument to the jury, I guess, on the penalty phase. And one of the most poignant and powerful things he said was, and I'll paraphrase it best I can, he said, well, Lisa Levy's mother wasn't there on January the 15th to plead mercy for her life. And Margaret Bowman's mother was not there on January the 15th to plead mercy for her life. Why give this man mercy? Well, perhaps, and it's rather ludicrous, but still, think about it. I wonder what would have happened if what Mr. Simpson proposed had taken place. Perhaps that tragedy in the Carmega house wouldn't have occurred. One never knows. So Mr. Simpson was asking for more than that. He was asking the jurors, and by implication asking this court, to behave in the same manner that the assailant at the Carmega house acted, without mercy. Vicious, cruel, without feeling. He was asking the jurors to lower themselves to the level of the person who committed those crimes, to seek vengeance. Draw blood. And now the burden is on this court. And I don't envy it. It's like, the court is like a hydra right now. It's been asked to dispense no mercy as the maniac in Carmega House dispensed no mercy. It's asked to consider this case as a man, as a judge. And you're asked also to render the wisdom of a God. It's like some incredible Greek tragedy. It must have been written sometime. It must be one of those ancient Greek plays that portrays these three faces of man. And I don't know how the court can reconcile those three roles because I think they're mutually exclusive, and the court is just, in spite of its experience and its wisdom, just a man. I'm not asking for mercy, for I find it somewhat absurd to ask for mercy for something I did not do. In a way, this is my opening statement. What we've seen here is just the first round, second round, early round of a long battle. And I haven't given up by any means. I believe that being able to develop fully the evidence which supports my innocence, being able to develop fully the evidence which we had, which indeed, I think, created a reasonable doubt. Being able to have quality representation, having these things, I'm confident that I would have been, in the event that I get a new trial, will be acquitted. It wasn't easy sitting through this trial for a number of reasons. But the main reason that it was not easy in the early part of the case was because of the presentation of the state's case on what took place in the Carmega House. The blood, the pictures, the blood-stained sheets. And to know that the state was trying to find me responsible for that wasn't easy. And it was not easy, nor did I ignore the families of these young women. I don't know them. And I don't think it's hypocritical of me, God knows, to say that I sympathize with them the best I can. Nothing like that has ever happened to anyone close to me. But I'm telling the court, I'm telling those people who were close to the victims in this case, I'm not the one responsible for the acts at the Carmega House or Dunwoody Street. And I'll tell the court, now I'm really not able to accept the verdict, because although the verdict found in part that those crimes had been committed. They erred in finding who committed them. And as a consequence, I cannot accept the sentence, even though one will be imposed, and even though I recognize the lawful way in which the court will impose it. Because it is not a sentence of me, it is a sentence of someone else who's not standing here today. So I will be tortured for and will suffer for it, and receive the pain for that act. But I will not share the burden for the guilt. That's all I have.
Are you going to say anything? Mr. Bundy, the court is going to sentence the person found guilty of the commission of the offenses at the Calamega House and Dunwoody Street. Your name, sir, was in the verdict form, and your name, sir, was in the indictment. That's what the jury found. Based upon that is what the court is going to adjudicate. And I say to you as sincerely as I can that appellate review is anticipated, it's provided for by law, and it should be pursued with the vigor that has been before this court in the trial. It's been a trying trial for everybody involved in it. The jury was taken from their homes, placed in a literal solitary confinement, and remained there for better than 4.5 weeks. And they spoke. That is a system upon which our jurisprudence evolves. The speaker of the trial was that. This court has labored long in consideration of the jury's verdict and in consideration of their recommendation. And I've reviewed the case from the first word of the indictment until the last word of the verdict returned yesterday afternoon. I'm going to enter the following judgment and sentence, consistent with after having reviewed all of that material. And as we develop this, I think you see where the court's coming from. I don't expect you to cry, Uncle. I'd be somewhat disappointed if you did. For I think the challenge that you presented to the court, to the system, is healthy. I find no problem with that. If we can't handle circumstances such as that, then appellate courts will review it, and you've still got to safeguard. And that's the way it ought to be. This court has no feeling other than we have tried to labor as fairly and impartially as I know how. And that's the way in which I'm entering this sentence. But you prognosed what the court was going to do. We're well aware of it. In viewing all of it as I will develop it, you'll understand that as the law is now written, there's no other approach. That's not to say that that law is etched in concrete or gold, but it is today's law. And it's upon that that the court is going to pronounce sentence. This cause came on before the court and trial by jury, and after deliberation a verdict was rendered, finding the defendant Theodore Robert Bundy guilty of the following crimes: burglary of a dwelling and assaulting a person therein, to wit Karen Chandler and Kathy Klein. Count 2, murder in the first degree, to wit Margaret Bowman. Count 3, murder in the first degree, to wit Lisa Levy. Count 4, attempted murder in the first degree, to wit Karen Chandler. Count 5, attempted murder in the first degree, Kathy Klein. Count 6, burglary of a dwelling and assaulting a person therein, to wit, Cheryl Thomas. Count 7, attempted murder in the first degree, to wit, Cheryl Thomas. After the defendant was adjudicated guilty by the court in each count, which the court has previously adjudicated in each count of the indictment, and the trial jury, after hearing additional matters, rendered and considered an advisory sentence pursuant to Florida Statute 921-141, 3. The jury returned, and an open court recommended that this court impose a death sentence upon the defendant Theodore Robert Bundy for the murders of Margaret Bowman and Lisa Levy. The verdicts were returned recommending death in both counts. This court, independent of, but in agreement with, the advisory sentence rendered by the jury, does hereby impose the death penalty upon the defendant Theodore Robert Bundy in 2 separate and distinct murders, murder in the first degree. In support thereof, as required by 921.141, 3, will submit, when final, prepared, the following written findings upon the death of each victim. In order to avoid duplicity, where applicable, the findings of aggravated circumstances will be stated as applicable to both counts. Separate enunciations will be made in those aggravated circumstances which were singularly applicable to the particular crime. Aggravation. A, that the crime for which the defendant is to be sentenced was committed while the defendant was under sentence or imprisonment. Finding of the court that the defendant stipulated that he was under sentence of aggravated kidnapping in the state of Utah, which had not been served, pardoned, or paroled, and that is applicable to both counts. B, that at the time of the crime for which he is to be sentenced, the defendant had been previously convicted of another capital offense or a felony involving the use of threat or violence to some person. The defendant stipulated that he had been convicted of the crime of aggravated kidnapping in the state of Utah, and that it was a crime involving the use of threat or violence to the person, which is applicable in both counts. C, that the defendant, in committing the crime for which he is to be sentenced, knowingly created a great risk of death to many persons. Findings. The defendant entered a sorority house where 30 or more girls lived, killed 2 and attacked 2 more. Every girl in the house was a potential victim and threatened. However, the court does not find any evidence of attack on any other girl or entry into any other room. Therefore, this aggravated factor is not proved to this court's satisfaction beyond and to the exclusion of every reasonable doubt. The crime for which the defendant is to be sentenced was committed while the defendant was engaged in the commission of or attempt to commit any robbery, rape, arson, burglary, kidnapping, or aircraft piracy, or the unlawful throwing, placing, or discharging of a destructive device or bomb. Finding. The capital felonies committed in this case were committed while the defendant was engaged in the commission of the crime of burglary. That is applicable to both counts 2 and 3. The capital felony was committed for the purpose of avoiding or preventing an unlawful arrest or effecting an escape from custody. There is no evidence of any aggravating factor, therefore the same is not applicable. The capital felony was committed for pecuniary gain. There is no evidence of this aggravating factor, therefore the same is not applicable. The capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of the laws. There is no evidence of this aggravating factor, therefore the same is not applicable. The capital felony was especially heinous, atrocious, or cruel. As to Margaret Bowman, count 2 in this information, the court finds that the victim was a young girl in a college at Florida State University. a member of Chi Omega sorority, living in the sorority house and asleep in her bed. The defendant stealthily bludgeoned and pummeled her with an object later described by identifying witness as a lager club of rough texture. She was struck several times about the head. She had a ligature around her neck, which was a pantyhose that strangled her and caused her death. The beating was vicious, vile, and wicked, and atrocious. Indeed, the testimony showed that the frontal area of the brain of the skull was fractured, jagged, and exposed a portion of the brain. She was left in her own bed in a pool of blood. Her body was mutilated and lifeless. As to count 2 of the indictment, the court finds that the victim was a young girl in college at Florida State University, a member of the Chi Omega sorority, living in a sorority house asleep and in her bed. The defendant, while the victim was in her bed, was stripped of her night clothing. One nipple was incised and bit off. There was also a bite mark on her left buttocks. There was evidence of vaginal and anal trauma, and she was left in a pool of blood in her own bed, her body mutilated and near death. She expired a very short time later. The court finds that both of these killings were indeed heinous, atrocious, and cruel, and that they were extremely wicked, shockingly evil, vile, and the product of a design to inflict a high degree of pain and utter indifference to human life. Now, the defendant chose to offer no evidence of any of the enumerated statutory mitigating factors, but chose instead to offer evidence to show that the defendant in the future could be rehabilitated and serve as a useful purpose for the rest of his natural life. This court declined to hear testimony concerning character of the death penalty, as it has been totally and completely considered by the Supreme Court of Florida and by the Supreme Court of the United States. Matters offered in rehabilitation were of a variety of witnesses: Catholic priests, ministers of Christian faith, his mother, and a journalist. The court has carefully considered all the evidence offered by the defendant and has further considered the total record in the case. C. Swan versus State at 322 South 2nd 485, for in 1975. The defendant sought habeas corpus ad testificandum for the law librarian at Rayford. The court declined to enter said writ because the court knows not where the defendant might be assigned in the schedule of the Department of Corrections, but offered, with the state's agreement, proffer of the testimony that the defendant might function as a law librarian. This the defendant declined. However, the court will consider this as a consideration in mitigating factors. Prior to the closing of the defendant's evidence in mitigation, the court inquired as to whether the defendant had been informed in counsel on each and every mitigating factor in the statute, but was tersely and disrespectfully informed that the conversation between counsel and defendant were privileged and that no meaningful response was given to the court's question. The court further considered the psychiatric report filed in this cause by Dr. Emil Tenay of Detroit, Michigan, a diplomat of the American Board of Psychology and Neurology. The course of the mitigation testimony shown by the defendant was calculated and deliberately designed to evade any reference in this court's mind of the statutory mitigating factors to be presented to the jury. However, this court is going to consider each and every one separately and independently in the discharge of its duties and consider the same in light of the total record that is before us. The court has considered no evidence or factors in imposing the penalty herein, and has no information not disclosed to the defendant or his counsel. which the defendant has not had an opportunity to explain or deny. See Gardner versus State of Florida and the respective sites. Mitigating circumstances. This defendant has no significant history of prior criminal activity. Finding. This circumstance has not been established, as the record shows that a defendant was convicted of the crime of aggravated kidnapping, extradited to Colorado, and escaped while awaiting trial in the state of Colorado. The capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. There is no evidence of any extreme mental or emotional disturbance at the time of the commission of the acts. That the victim was a participant in the defendant's conduct or consented to the act. There's no evidence that either victim in this case consented or was participating in the act. That the defendant was an accomplice in the offense for which he was to be sentenced, as was an accomplice in the offense for which he is to be sentenced, but the offense was committed by another person and the defendant's participation was relatively minor. There is no evidence that anyone other than the defendant participated in the offense. All the evidence is to the contrary. The defendant acted under extreme duress or under substantial domination by another person. This mitigating factor is the element of substantial domination of another person is not applicable. However, the extreme duress element will be discussed by the court simultaneously with mitigating factor F, the defendant's capacity to appreciate the criminality of his act, of his conduct. The capacity of the defendant to appreciate the criminality of his conduct or conform his conduct to the requirements of the law was substantially impaired. The psychiatric evaluation report of Dr. Tanay, previously filed in this cause and considered by the court in a competency proceeding, indicated that the defendant makes decisions based upon distorted perceptions of reality. And due to the behavior of the defendant, it appears accurate to say that he attempts to conceal and reveal his involvement simultaneously. That is, dealing with the criminal justice systems are dominated by psychopathology. This court has carefully considered this report in an attempt to determine if the defendant possessed an impairment of his ability to appreciate the criminality of his conduct, or whether the perception of an extreme duress is within himself. This court is of the opinion that while the pathological needs for the defendant are consistent with defiance of authority and manipulation of all people that he contacts, as the report states, there is no overall symptomology of a personality disorder or substantial impairment of ability for the defendant not to appreciate the criminality or to establish the presence of extreme duress. This court has observed the demeanor and the actions of the defendant throughout this entire trial. And while a number of incidents appear antisocial, they do not, in this court minds, indicate or demonstrate a reduction of appreciation by the defendant of the criminality of his act. I find there are no mitigating circumstances in either circumstance E or F. The age of the defendant at the time of the crime, finding the defendant is now 32 years of age. There is no mitigating factor. The crime occurred January 15, 1978. Upon the preceding specific findings of fact, the court bases its sentence. It is of the opinion of this court that there are sufficient aggravating circumstances existing to justify the sentence of death. The aggravating circumstances are so clear and convincing that virtually no reasonable person could differ. The court is mindful that the sentence must be a matter of reasoned judgment rather than an exercise in discretion. See Rollison v. State at 358 South 2nd, 826, Florida, 1978. It is this court's reasoned judgment that no mitigating circumstances, either statutory or by the testimony presented in the advisory sentence proceedings, have been proven to this court or exist to impair the thrust of the aggravated circumstances which have been proven to this court beyond and to the exclusion of every reasonable doubt. This court therefore agrees and concurs with the advisory sentence in the recommendation entered by the trial judge. It is therefore the sentence of this court, count 2 of the indictment, you, Theodore Robert Bundy, be adjudicated guilty of murder in the first degree, and that you be sentenced to death for the murder of Margaret Bowman. As to count 3 of the indictment, you, Theodore Robert Bundy, be adjudicated guilty of murder in the first degree, and that you be sentenced to death for the murder of Lisa Levy. It is further ordered that you, Theodore Robert Bundy, be taken by proper authority to the Florida State Prison, and there be kept and closely confined until the date of your execution is set. It is further ordered that on such scheduled date that you be put to death by a current of electricity sufficient to cause your immediate death, and such current of electricity shall continue to pass through your body until you are dead. The death sentence is imposed in both counts 2 and 3 for the deaths of Margaret Bowman and Lisa Levy, independently and separately. You're notified, sir, that a judgment of conviction and sentence of death under the law of Florida is automatically and will be fully reviewed by the Supreme Court of Florida. In other counts of the information, count 1, burglary of a dwelling and assaulting a person therein, it is the sentence of this court, sir, you've previously been adjudicated guilty, that you will serve 99 years in the state penitentiary. As to counts 2 and 3, the court has previously announced. As to count 4, attempted murder in the first degree, this court is the opinion that the underlying felony in this count is indispensable to count 1, and the court will impose no sentence. See Florida versus Pender, 1979, released July 5, 1979, Supreme Court case number 55369. Count 5, attempted murder in the first degree. The underlying felony in this count is indispensable to count 1, and the court will impose no sentence based on the same authority. Count 6, burglary of a dwelling and assaulting a person therein. The court sentences you to 99 years in the state penitentiary. That is consecutive to the sentences that are imposed by this court in counts 1, 2, and 3. Count 7 of the information, attempted murder in the first degree. The underlying felony in this count is indispensable. As to count 6, and the court will impose no sentence on the previous authority. All sentences imposed on counts 1, 2, 3, and 6 are consecutive. This court also invokes Chapter 78 through 18, now 947.16 of the Florida statutes. That is to say that the court retains jurisdiction over the offender for review of any future release order for the Florida Parole and Probation Commission for 1/3 of the total consecutive sentences imposed in this case. The court finds that ample justification exists for the entry of an order by this court retaining jurisdiction over Theodore Robert Bundy for review of any further release order of the Florida Parole and Probation Commission, in this regard specifically finds That these crimes involved a burglary of a sorority house with 30 or more girls, wherein 4 were brutally beaten and with 2 being killed. That the girls in the sorority house no way participated in the suggestion of or consented to the entry for criminal acts. One case involved the entry into a private home, and one count wherein the sleeping victim, also a young girl, was left with 5 skull fractures. The defendant has a history of prior criminal activity. These crimes committed involved extreme savagery, indifference of human lives, and the infliction of agony and pain upon the helpless young women. The defendant has maintained a complete indifference to the commission of these acts, and the court hereby directs that the Florida Parole and Probation Commission to send to this court or its successor and to the state attorney notice as provided in Florida Statutes 947:16 2C of any future release order of the commission for appropriate review by this court in accordance with the provisions of Florida Statute 947:16. Be advised, sir, that as to the judgments and sentences imposed in count 1, 4, 5, 6, and 7, you have the right to appeal within 30 days from the date of these proceedings. You're further advised that you have a right to the assistance of counsel in the filing and preparation of your appeal. Upon your request and showing that you're entitled to an attorney at the expense of the state, an attorney will be appointed to represent you. This order is done and ordered in open court in Miami-Dade County, Florida, this 31st day of July, 1979, AD. Fingerprint the defendant.
I want an open court.
I issue the commitment order. This court will enter one other order in this cause, and so counsel understand that I'll enter it, but I'll publicize it at the same time. The cause came on to be heard on the court's own motion. The court having heretofore entered a change of venue from Tallahassee to Miami, Florida, and appears that the trial has been had and sentence imposed, therefore the court find no reason to retain the file and matters appertaining thereto in Dade County, Florida. It is further ordered that this entire file, the exhibits introduced at trial, transcripts of testimony typed and filed, and any exhibits offered and proffered for identification be returned and filed with the clerk of the court of the 2nd Judicial Circuit in and for Leon County, and that any further proceedings in this cause shall be conducted and heard in Tallahassee, the county seat of said county. You may file and distribute copies now, sir. Here's another motion that's filed. The court will consider for due course. This court will be in recess and adjournment in this case.
Your Honor.
Everybody remain seated.
Hold on just a minute, Mr. Bundy.
The earlier request that I made concerning...
We'll grant you.
Is there some way my family can get out of here before the news media get on?
Can we escort them out the back way? We'll take care of it. I'll get them to see you, sir.
Thank you.
Take care of yourself, young man.
Thank you.
I say that to you sincerely. Take care of yourself. It's a tragedy for this court to see it's such a total waste, I think, of humanity that I've experienced in this court. You're a bright young man. You made a good lawyer. I'd love to have you practice in front of me, but you went another way, partner. Take care of yourself. I don't have any animosity to you. I want you to know that. Take care of yourself.
Court will be in recess. Remain seated, please, till the judge is out of the courtroom.
What's your...
Court is now in recess. Please clear the courtroom. Well, later. Not right now, son. It's a little more important. They work some justice stuff.